welcome. Good morning, everyone. Welcome. You're listening to High Frequency Radio. I'm your host, Yusef. Gonna get it in today. It is March 27th, 2013. We're on a Wednesday. Hump day, y'all. That's for everybody out there on the plantation tuning in to me. Yeah. I'm gonna drag you. Nah, I'm just tripping. I know y'all gotta do what you gotta do. But today we're gonna talk about court tricks and traps. Why did I pick this topic? Because I think it's the number one thing that catches people up. You know, you got a lot of individuals that go in these courtrooms, they challenge jurisdiction, they do all these different things, and then they come back and say, it didn't work. That don't work. Crying and shit. Don't try that shit. You gonna get locked up. You go in there and try that shit with them folks. You scary motherfucker. Anyway. This is going to work not only for criminal cases, but also for the foreclosure cases. We may have some foreclosure people in here. I don't know. If they have gotten to the point where they recognize or realize that you're not dealing with a real court system. You know, they the foreclosure people, they a trip. You know, they kind of the foreclosure groups, they're battling the good fight, and they just they just constantly want to believe that we are actually have a real court system or something. I don't know. But what these are, y'all, these are administrative courts. These are not Article 3 courts. Let me get that in everybody's head. And when you go in there trying to challenge jurisdiction, the judge is going to try to trick you. And the only way that you can overcome the trick is you gotta know what you're doing. You gotta know what you're doing. I'll share a little story with y'all. I was on a foreclosure case, and this case actually made television. They never showed it on television because, when you go, one thing about these people is they really believe that everybody else is stupid. Like they're the only people that have intelligence. I mean, especially if you're a black man. If you're a black man, that's automatic. You've been slated and relegated to the category of damn fool, especially when you walk into a courtroom. So we are doing this show to show them the error of their ways, because they don't seem to understand that, things will be revealed in the last day. And the mask has been pulled off, as they shall say. Well, anyway, I'm in court, and I'm on a foreclosure case, and, I'm in there. They got the television cameras in there because they say I'm stealing houses. They say I'm stealing houses. I mean, how the fuck do you steal a house? I mean, I don't even understand that shit, But the bank said I was stealing from them. Everybody in the foreclosure community, you have to find that amusing. I mean, the thieves and the murderers are mad because they got pickpocketed. Well, anyway, I go in there before this judge, and they call the case. And prior to that, that what they try to do is they try to get you to go into arbitration or something like that, mediation, before you go into court. See if you can resolve this issue privately first, according to Matthew 5:25. Which is why you do an administrative process. The administrative process is you are attempting to get an agreement with your adversary before you ever go to court. But many of you don't do that. And many of you don't put a bond in the case or anything like that. We're going to talk about all that too. Because this is admiralty. You're going into a business court now. That's why the attorney needs a license, because you need a license to do business. All right. So you also a businessman or a businesswoman is identified how they dress. So you always wear a suit when you go into the court. Dress appropriately. You have to bond the case because the people you are all going against, they're all bonded. What about you? Are you bonded? You have to put a bond in on any case that you go into in these particular proceedings, and you need an affidavit. I'm appalled, just for all you foreclosure people out there, of how many of you put in complaints for quiet title or petition to set aside foreclosure or removals and all this other stuff that you're doing, and you do not even have an affidavit in on the case or a bond. Yeah. These are simple things. Once again, I'm going to direct everyone to read creditors and their bonds if you want to learn how to do the admiralty, equity, probate, administrative law venue, because that's what you're in. You're not in a court of law. Well, anyway, I'm up here before this judge. I couldn't agree with nothing with the police, with the attorney in the back. I mean, what are we going to agree about? I'm not giving you the house. So what is there to talk about? I'm not giving you the damn house. Matter of fact, I'm going to suggest that you take your ass back to your law firm, because there's going to be some serious issues if you try to take this house, Well, anyway, we go back into the courtroom, and lo and behold, there is another attorney there. The attorney I'm talking to in the mediation is not even there, y'all. They got another attorney, a CID. You have to listen to one of my past shows to know what a CID is. These are black people that resemble they look like black people. Let me put it like that on the outside. But once I go in there and I see this other attorney, I said, okay, so they called a case. And the attorney starts walking up to the bench. He wants to hand the judge all his fake-ass documents, because those are fake documents, They're copies of copies of copies of copies, and, they're trying to steal your house with, I mean, where I was at, they didn't even put in certified copies, but, anyway. So objection. I said, objection on the hearsay. We need someone who can come in with first-hand knowledge of the contents and the veracity and validity of the contents of those documents. Yeah, like that. Bam. We're on television, too, y'all. There's a camera in there. Channel 2 News is there. Jody Fleischer then sent her hit squad to come and look at me and said, look at this black man stealing houses. Look at these Moorish nationals. What is this Moorish national thing? Y'all stealing houses. Y'all done found a scheme. But, I don't see you investigating banks, walking through neighborhoods, finding vacant houses, and then just going in and just filing a dispossessory. No paperwork, no nothing. I've run into that several times. But you can't get Channel 2 News to even look at that shit. You can't look at them and say, well, why did you call SWAT to kick a woman and a man in a wheelchair out of a house. I mean, if that's not some bitch shit, I don't know what is. I mean, that's some bitch shit. How can you people out there work for the police? I mean, you got to bring SWAT to put two people. What? That is some bitch shit. I'm just gonna call it likely as you are bitches. Grade A bitches, okay? Anyway, and everybody knows, y'all know shit. Y'all be looking at the news, and y'all see that shit. And you don't say, but you whisper to them like, damn, they took all them police to get them. Them some real bitches. But anyway, so I'm in here, and now the judge, when you do an objection, all you want to hear, and of course, y'all, you have to have a court reporter. If you do not, I got to repeat this every show because somebody is going to always come and talk to me. Because I know you're saying you couldn't afford a court reporter. It's expensive. They didn't have one in the courtroom. It's your responsibility prior to going to court to make sure there is going to be a court reporter available. If your life or your property is on the line, I would strongly suggest that you go ahead and sacrifice and dig into your pockets and pull out the money for the court reporter. Because it is very and vitally important that you have that, the record. Because that is the judge. That's the court. The court is the court reporter, not the judge. If you don't have a court reporter, you didn't have court. How are you going to appeal when the appellate court looks at the stenographic record of the proceedings? But you're going to appeal. You're just going to give your money away. That's what you're going to do. But anyway, so when the judge doesn't say sustained or overruled, this is what you're looking for now. You're looking for the judge to say sustained or overruled. That's it. That's all you want. If they don't say that, they're trying to trick you. Here's trick number one. This is a trick. Not saying sustained or overruled is a trick. They are equivocating. They're trying not to commit on the record because they know that they are about to allow some bullshit evidence against you so they can steal your home or your life. And they don't want the liability for it, so they just start, gaming you like, well, Mr. Johnson, I think I'm going to let this evidence in. It looks like it is certified. It's coming from the clerk's office. I don't see why you're objecting, or something like that. It's going to be, some bullshit that they're going to try to give you. And your job is not to fall for it. Now, what do you do? What do you do? You have to do what's called an exception. See, a lot of y'all out there, y'all know about objection. What you don't know is exception. I had a judge tell me one time, Mr. Jones, what do you mean exception? Well, no, she said, you mean exception like like there's an exception to the rule, or are you taking an exception to my ruling? You take an exception to the ruling. So when they don't say, sustained or overruled, you can say something like this. You can say something like, I take exception to the judge's refusal to rule on my objection. Would you please enter sustained or overruled into the record so I can preserve the error? That's one way you can say it. Or you can say, let the record reflect in an objection to the hearsay testimony of lawyer Shyster, Lucifer Law Firm, has been made that the court has neglected or refused to rule on the objection, and I have objected to the court's neglect or refusal to rule. Now, there's a document on the internet. I'm going to put it up in the chat room right now. Y'all can pull it up. It's called Court Tricks and Traps. It got all this stuff in there. Y'all better read it. It's in Texas, but it's good in all 50 states. It don't matter. They got the same principles in all 50 states. Tells you how to do an offer of proof. All these people out there, y'all fighting these foreclosures and all, y'all got to know how to do all this stuff. You got to watch out for the tricks. Another trick in foreclosure that they may give you, okay, well, now let's switch to criminal real quick. To the Moors and out there. You know, you got the Moorish people out there who are going into the courtroom and challenging jurisdiction of the court. Now, that I don't have a problem with that. That is fine. You can challenge the jurisdiction of the court. But if the court does not have jurisdiction, why are you answering questions and following directions? See, the judges, they are very, very shrewd. You come into the court, you do something like, I'm a Moorish national, and I'm here under the Treaty of Marrakesh, and I'm challenging the jurisdiction of this court. I'm a real living soul, a man of the land, an aboriginal man. However you're going to come in and say it. You do your whole spiel. And then the judge comes back and says something like, well, sir, take off your hat when you're in the courtroom, sir. Or, I'm sorry, sir, it says right here that your name is Bill Johnson. Is that not your name? Or, what is this other name? Anything. They may just try to engage you into casual conversation. What you have to understand is that they are public and you are private. Anytime they can't see or hear you until you make an appearance. The word appearance means to subject yourself to the jurisdiction of the court. And you have two types of appearances. You have a special appearance and a general appearance. Now, they're saying for all intents and purposes on the federal level that special appearance has been eliminated. But I think you can make a restrictive appearance or something like that. I got to look up the code, but I know you can make you can always challenge jurisdiction. Now, they have two types of jurisdiction. They have an in rem jurisdiction and an in personam jurisdiction. They never have in personam jurisdiction unless they can establish the minimum contact requirements. Remember, I told y'all about minimum contacts. But these proceedings, especially in criminal cases, are always in rem. And when you study admiralty law, you will see that the majority of proceedings in admiralty are in rem proceedings, which means against a thing. Now, the interesting thing about the word thing, because that is a word that you should look up in a Black's Law Dictionary, is that slaves are considered things. Wow. That's very interesting. Which is why the judge has to test you to see whether or not you are a thing. And that's when they go about with the questions. So, when you're in these proceedings and you start answering questions, hell, your ass is given jurisdiction. You are participating in a public play. When you go into the courtroom and you bonded the case, you've done your administrative process, maybe you've given them some GSA bonds or something like that, you are there to get your point across. It's your case. We're here to talk about what I want to talk about. We're not here to talk about what you want to talk about. So the first thing out of your mouth should be, are we on the record? That's a question. See, a question is not answering questions. The person who is asking questions is in charge. The person who is asking questions is in charge. So let's say they ask you about your name. They say, well, I need your name because if you don't give me a name, I'm going to have you not appear. They've done this to me before. They did this to me and came out of the court and kidnapped me on the sidewalk. I was leaving, So I'm giving y'all experience and everything. They will kidnap your ass, you know, especially if you get one of those judges who just, you know, in these counties where there's just absolutely no black people and they think black people are, you know, have the audacity to walk around and think that they're really free. You know, you got those out there that are still walking around. When they still got their sheet in the cleaners, their white sheets, they just went to the cleaners, those types. I'm not talking about all white people. I'm not talking about all white people. You know who I'm talking about. You who just took your sheet off, or you're sitting in your sheet right now listening to this radio station. But anyway, so what'll happen when they ask you for your name? You know, you got to understand, before you answer any questions, you got to establish, you know, certain things procedurally. And you could say something to the effect when they ask you your name. I have not seen charges formally entered into the record. Do you formally, you can say, I'd be more than happy to provide any information as long as it can be demonstrated that charges have been formally entered into the record. Have charges been formally entered into the record? Say something like that. They will come and try to give you your charges or something like that because they don't like to read charges into the record. Pay attention to this. It is all about escaping liability. 99% of the people in prison and everything, they go there because, you know, they ain't even read the charges into the record. And then when they do, because they will, because they know people are finding out about this, they'll try to, the prosecutor usually reads it, you won't ever see that prosecutor again. They'll ship them somewhere else. They'll start talking about they're pregnant, they're about to have a baby, they have to take time off, all that shit. You'll see another prosecutor and probably even another judge sometime during the course of the proceeding. But you concentrate on an individual who read those charges into the record because they got to pay. They got to pay. I hope they're out here listening. They got to pay because they're taking on all the liability on that particular case. Now, when they do read the charges, you can come back and say, do you have a claim against me? Do you know of anyone who does have a claim against me? You start asking them questions about who has the claim. Because they're trying to put a lien on you. And for there to be a lien, there has to be an assessment. There has to be a verification. There has to be something that's sworn to under penalty of perjury. There has to be an order of the court. There has to be a delegation of authority. They have to have paperwork going on in the background to substantiate the charges. They have to have an original matrix. That means original charging instrument. They need all of these things. So before you get to flapping your gums and all of this, you want to be seen that. I got a case right now I'm working on. They used an information, you know, and that ought to tell you something else. Informations are used for corporations. I was able to find that in a law library. In California, use a lot of informations to send people to prison. But informations originally have the purpose for indicting a corporation. So what are they telling you? Or an accusation. They just totally ignore. Here's something else. They totally ignore. Totally. Now, why y'all ain't asking this question? Why are y'all not asking these people this question? You know, I've seen this in a law library. It's the Sixth Amendment. It's the Sixth Amendment of the Constitution for the United States of America. Let me read it to you. Now, this is supposed to be the highest law of the land. And hear what it say. It say, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. Notice that state with a capital S. And district wherein the crime shall have been committed. Notice they said and district. Which district shall have been previously ascertained by law. and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Wow. Oh, I'm sorry. That was 6. Let me read the Fifth Amendment to you, too. I got a little mixed up. But I'm going to go back to the Sixth Amendment because that's important. This is what you're going to ride off of, these 2 amendments, the Fifth and Sixth Amendment. The Fifth Amendment is the due process clause for real living people. The 14th Amendment is the due process clause for corporations. That's for your straw man. But anyway, it says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now, what's interesting about this entire thing is the word presentment. What you're going to find when you look in a Black's Law Dictionary is that all your words usually have an Article 3 definition and an Article 1 definition. They have a commercial meaning, they have an at-law meaning, and an in-law meaning. They have dual meanings. To understand what word is going to be applicable and that you're going to be using, you need to know the nature and cause of the action. You need to know under which court you're operating. Just because I say court, that doesn't tell you anything. Are you on a tennis court or a basketball court? I need to know what kind of court. So just calling it a court doesn't mean anything. Is this an Article 1 court or is this an Article 3 court? All right, so we need to know these things. But let's look at this word presentment real quick. Presentment is a very important word. In commerce, presentment. Okay, well, here it is. Presentment. Okay, look at the first definition. In the first sense of the word, it says the act of presenting or laying before a court or other tribunal a formal statement about a matter to be dealt with legally. Now, here's the second sense. In criminal procedure, it says a formal written accusation returned by a grand jury on its own initiative without a prosecutor's previous indictment request. And then here's the third sense, which usually is always your commercial sense, 3 times. The formal production of a negotiable instrument for acceptance or payment. Now you'll see right there you got 3 senses of presentment that can be used. Now, obviously, if you're in a commercial court, the third definition is going to apply because we're in a commercial court, so you got to use commercial terms. If you're in an Article 3 court, in a court in law, then of course you're going to use the other sense because we're dealing about lawful matters. This is just a small example of why it is important to ask questions. Because you are going into the court and they are saying things to you and you're answering the questions, and when you answer a question, you are presuming that you understand what they're saying. It's a presumption. You don't know what they're saying. I like David Wynn Miller. I'm going to give David Wynn Miller a plug. The man is nice. I'm listening to him. He's on YouTube. Y'all should check him out. It's the mathematical interface of language. And I got to give him his props. He's nice. He's nice. He's nice. And he did a nice little example. He said 2 plus 2 equals 4. 2 plus 2 equals 4. Now, a lot of y'all out there think y'all know the answer to that. But no, there's a lot of variations of 2 plus 2. I can spell 2 T-O, T-W-O, T-O-O. So I can do T-O-O plus T-O equals F-R, F-O-R. Or I can spell 4 F-O-R-E. Or I can spell 4 F-O-R, F-O-U-R. I mean, so I can interchange them words 2 or 4 in a number of different ways. So it's called an item sonin. It sounds a certain way, but do you really know what I'm saying? This word presentment. In what sense am I using the word? All you notaries out there in California, y'all get tricked too. You scary mother. I came out here, boy, y'all, they just have cut y'all's nuts off and handed them to you out here in California. They changed a little bitty phrase in a statutory code saying that you could do protests for financial institutions. Not one of you lazy, not one of y'all went and looked up and seen what the definition of financial institution means, because you presume that you already know. You presuming that you already know. Okay, I got people with their hands up. I'm going to take a quick call real quick. 302-7419. What's happening? You're on high-frequency radio. What's going on?
Hey, family, two questions. You said you're going to call, are we on the record for the you say are we on the record, right?
Yeah.
If they say no, what do you do after that?
Okay, well, I need to get a court reporter in here. I need to be on the record for appellate purposes.
I got you.
You know what I'm saying? But you need to really, I'm going to tell you the truth. If you out and you free, you need to make sure there is a court reporter in that courtroom. Because if you ain't free, they just going to kidnap you and just do what the fuck they want to do anyway, because it's just what they are. They're low-down, just dirty motherfuckers like that. So they'll just, they'll tell you you're going to go to court, and your people don't know. They're going to drag you in there. Ain't no court reporter in there, try to scare you into saying something. Oh, you need to take this plea right now. You're going to trial right now. Just something. A lot of people don't know that's going on behind the scenes, but that's what behind. But if you're free, always get these people on the record. Always get them on the record. Get their words. Now, let me tell you something now. When you do get on the record, that can work for you or against you, because they real slick at manipulating the record too. Always remember that anything you say can and will be used against you.
Right.
Anything you say can and will be. It doesn't say might.
Right. Now,
so it's a word game. They wordsmiths. They use words of art. So you got to be very careful. So a lot of people, when you come in there and you're challenging jurisdiction, you ain't got to answer a goddamn question if they don't have jurisdiction. You ain't got jurisdiction on you. I don't answer shit. I'm not doing shit. You don't care. You give me an order to take a mental evaluation, you can stick that up your ass. You don't have jurisdiction. I'm not doing nothing until you demonstrate. An order from a judge means absolutely nothing. It can be challenged anytime. So what the fuck? Enter an order. Now, order is also a very interesting word. Another very interesting word, order. Let's look at that word. Order. Once again, we have different senses of the word. I'm coming out of a Black's Law 8th edition. Order. We have the noun, a command, direction, or instruction. It tells you to see a mandate. Well, that's sense number one. Let's look at the rest of them. Order, a written direction or command delivered by a court or a judge. That's sense number two. Now, let's go to 7. Okay, they got so many for parliamentary law, but let's look at commercial law. And when it went beyond 3, they tell you, okay, commercial law, sense 7. The words in a draft, such as a check directing one person to pay money to or deliver something to a designated person. Now, so if we're in a commercial court, when they issue an order, they are directing you to pay some money. That's what that is. That's a money order. Well, we don't know that until we find out what jurisdiction that they're operating under. So if we are in a commercial court, and if you say the word order, we got to use commercial terms. another reason why it is very important for you to understand, is this an Article 1 court or is this an Article 3 court? And for all of you, if this is your first time tuning in on this show, you cannot go into the court and ask the judge, is this an Article 1 court or is this an Article 3 court? You got to trick him. You got to trick him, y'all. Let me show you how you trick the judge. You got to trick him. You got to play stupid. You got to come in there and say something. Well, you know, look, I'm confused. I'm confused. I'm confused. Well, what are you confused about? Well, first of all, is this a civil or criminal action? Now, you're asking these questions because, you know, he is, you know, you're building up into something. You're getting them to, you're getting them to flow with you a little bit. And, hey, this is but some of them know this trick right here. They start, as soon as you ask the question, I'm not playing games with you today. Well, shit, I'm not playing no damn games either. You trying to take my house or lock me up in jail? What the hell you think I'm playing games? I would say something like, if they say you playing games, because it's one of their favorite little statements to make, you can say something like, well, I will conditionally accept the judge's contention that I'm playing games upon proof of claim. You could provide me some points of law or something to that effect, and me asking you these questions when this court is trying to take my house or my liberty can be construed as playing games. You got to address everything they say, because even when they say you playing games, that's a presumption, and if you don't properly rebut it, it's going to go on the record that you're playing games. Do you understand what I'm saying? Everything that particular administrator is saying on the record has to be properly addressed. Everything. Because they're contracting with you, and silence is acquiescence. So if they say anything and you don't properly respond to it, then you agree and they have a contract with you. And as a matter of fact, it's been expressed because we have a court reporter over there on the side typing it up. So I'm not answering any questions. I'm asking the questions because I need clarification. So after asking if it's a civil or criminal action, you'll get criminal action out of them. You say, okay, well, let the record show that the action being brought against the defendant. Now, notice I said being brought against the defendant. You are not the defendant. The defendant is a thing. The defendant is the trust corpus, the res, R-E-S. Look that word up. That's a legal word, R-E-S. Now, let the record show that the action being brought against the defendant is a criminal action. Now, you're going to ask him another question. Okay, well, sir, well, I have another question. The Sixth Amendment, what I just got reading, says the Sixth Amendment only grants this court two criminal jurisdictions. One is under the common law, which is Article 3. When you're common law, you should automatically win Article 3. And the other is a jurisdiction that constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Article 1. Admiralty is debt collection. Admiralty means bonds. This is admiralty. This is what admiralty involves. Admiralty involves contracts. Under which two jurisdictions is this court trying this criminal action? You want to know that information. Now, this is a question that they never answer, so do not expect to get an answer out of it. What you're going to get is an attempt to trick you again. They're going to give you some bullshit response about statutes, codes, rules, and regulations, California Civil Code, the Official Code of Georgia annotated, whatever. They're going to give you something like that. And what that is, that is not mentioned anywhere in, let me read the Constitution for you again, because I haven't seen that anywhere in the Constitution. But this is the Sixth Amendment. And for all of you who haven't read the Bill of Rights, I would strongly suggest that you read the Bill of Rights. Hell, your children should have that memorized, not the fucking Pledge of Allegiance. But Anyway, in the Sixth Amendment, it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Now, let me talk about that. If the Constitution says I got a right to a speedy trial, then why do I have to have a Speedy Trial Act? Why the fuck do you need a Speedy Trial Act if the Constitution already gives you a right to have a speedy trial? Because that's statutory, and that's for the straw man. The straw man has to have some rights, too, so they have to write stuff for corporations so they can have a right to a speedy trial. Because the Constitution already protected the real living man's soul. It protected his God-given right to due process. But we need to have those same rights of due process for the fictional entity. We need to have a due process clause for the corporation. And voila, the 14th Amendment. Now, I hope some of you out there did your homework for Monday and watched Lincoln. Lincoln is not an action-packed thriller. It is it is for intellectuals who want to sit with some coffee and a blunt and watch it. It is not for you to come in and look and think, okay, I'm going to, do this. Whatever you're going to do, you got to sit and concentrate and focus on what is being said in that particular movie. Pay it close, especially after about 30 minutes into the movie. Pay very, very close attention when Lincoln is talking about seizing the property of the South, i.e. slaves, and bringing it into the United States. Pay very close attention to that. Well, anyway, let me keep going. It says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. These jury roles, we found out that sometimes they be bringing back indictments, and, in some states they give you a list of the people on the grand jury. Check that sometimes. I think you may find every now and then that some of them people on the grand jury are dead. Wow. How did they bring back a true bill? They don't let it slip that often, but every now and then you can catch them because they rubber stamp them indictments. Trust me on that. Anyway, okay, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Oh, well, there it is right there. They always like to give you the cause of the accusation. Mr. L., you had 50 dead bodies under the house and 20 AK-47s and, $50 million in cash. How do you plead? That's the cause of the accusation. I need to know the nature of the accusation. There is a distinct difference. The nature, is this Article 1 or is this Article 3? Is this in the nature of a contract or is there an injured party? Is this Roger Rabbit or is this, something real? Are we in Toonland? Are we in the Republic? Is this about a corporation or a real man? What's the nature of the accusation? Now, they're not going to want to tell you this because they low lifes and they are in the business of sheep herding and slavery, and they don't feel like, as a public servant, you are worthy of them responding to that because you haven't demonstrated that you can lean them up, take every damn thing that they own. You haven't shown them that. So you're not anybody they need to be afraid of. I've really come to the conclusion that you do have to get these people to put you on a do not fuck with list. And we're going to do this with our minds, to get them to put you on the list. Think about this, y'all. How did the public servants get so much control? I'm just, how, think about this. Think. How did public servants get so much control? I mean, it's wild. It's crazy. Because we gave it to them. So we're looking for the nature, right there, or get on your internet and Google it. Google Sixth Amendment of the Constitution for the United States of America and read it. So when he don't want to give it to you, you say, let the record reflect that I have demanded that the administrator provide me with information as to the nature of this particular action under the authority of the Sixth Amendment for the Constitution of the United States of America, and he has failed in that endeavor and intends to proceed in this criminal action under a secret jurisdiction known only to attorneys and judges. Get it on the record. You're not going to like that shit. As a matter of fact, you're going to try to get your ass out the courtroom ASAP. And if you locked up, he's going to have the bailiff remove this man. But it don't matter. Just get it on the record. You know, you just want to let them know that you are not bullshitting. Just let them know. Let these people know that you have absolutely no fear of them. Look them dead in the eye. I don't give a damn if he's frowning. They like to frown and shit. That's an act. You don't give a damn about them frowning. Look them right in his eye and frown back. And ask him a question. Look him in the eye, and your eyes should be saying, you piece of shit. I know what you're doing. That's what your eyes should be saying when you look at him. Just look at him like that. Just stare through his soul and say, you piece of shit, you know what you're doing. He's not going to want to tell you the answer to that question. He's not going to want to tell you. Now, he may come back with another trick. I'm not here to give legal advice. That's another one of their favorite tricks. I'm not here to give legal advice. You need to get you an attorney. I would strongly suggest that you get an attorney. How do you respond to that one? Well, you could say something like, I'm sorry, sir, I'm not seeking legal advice. What I'm trying to determine is your legal intent. Now, the Sixth Amendment of the Constitution for the United States of America. Now, notice I always say spell it out all the way because they hate every time that you say Constitution for the United States of America. It's like rubbing your nails across a chalkboard. They just chagrin. You say Constitution for the United States of America, and they just fall out. Because the Constitution don't apply in these courts. It don't. It has no place. They didn't told some of y'all that, too. Y'all didn't tell me the Constitution. The Constitution is a moot point, absolutely irrelevant in these proceedings because they're in there enforcing a contract, and contract makes the law. I know some of y'all want to argue with me about that, but I'm pretty sure I'm right on this point. Contract makes the law. It is an invisible contract. And you need to question it. You know, they're not going to put it on the record, but it's a contract nonetheless. So you say, I'm not seeking legal advice. I'm trying to determine your legal intent. Now, the Constitution for the United States of America grants me the right to know the nature of this action, and it makes incumbent upon you and makes it a duty for you to tell me, because didn't you take an oath to uphold the Constitution? Matter of fact, if you've done all your due diligence and were proactive before coming into the courtroom, you have within your hands a certified copy of his oath of office. Now, how do you put his oath of office into the proceeding? You read it into the record. Yeah, Jan, I got something I want to add to the record. And you read his oath of office. Here's your oath of office I like to read, and read that shit into the record. Another way of invoking common law. Didn't you swear to uphold the Constitution of the United States? Didn't you say, oh, help me, God? Was you talking about the God of truth or the God of lies? Because in the Bible, it says that Satan is the God of this earth. So which God did you swear to uphold to? So we got to find that information out too, because they're not going to tell you. Now, sir, in order for me to effectively represent myself in my proper person, you never go into court pro se. In order for me to effectively represent myself in my proper person, I have to be informed of the nature and cause of this action. Because the rules under an Article 1 court are vastly different than the rules of criminal procedure under an Article 3 court. At this point, he's probably going to say statutory jurisdiction. Now, let me tell you, some of y'all are aware of what I'm telling you. If it ever comes out of his mouth, California Civil Code, official code of this, or this state code, or this statutory jurisdiction, or whatever, he has just committed the entire proceeding to a jurisdiction that does not exist. You have won the case. Everything after that is going to be a trick to try to recontract with you, to fatigue you out, to get you to do a guilty plea. See, they like guilty pleas because guilty pleas kill all known and unknown defenses. So it doesn't matter what mistakes they make. Their last bastion of defense is to get you to plead guilty. And if they can get that, they could have did all the corruption in the world. Doesn't matter. Guilty pleas kill all known and unknown defenses. Remember that, okay? Add that to your library, your mental note. All right. Did I answer your question?
Not really. But
I didn't? Okay, well, ask it again. I'm long-winded. I'm tripping today.
You answered a little bit, but you took me way out there. You lost me, right? But one more thing. Can you? We still in the courtroom, right?
Yeah, we're in the courtroom.
I wonder if I go up there and I say, "Excuse me, you're trying this. I see them gold fringes around the flag. You're trying to try me in a military tribunal. You don't have no jurisdiction over this matter."
Well, ask him that. Don't tell him. Don't be telling him things. Ask him questions. I'm sorry, sir. I noticed that you have a flag behind you that strangely resembles a Navy military flag that usually indicates some type of admiralty jurisdiction. Are we operating under an admiralty jurisdiction? Is this some condition of contract under of a colorable admiralty jurisdiction or something to that effect? Always pose it in a question. Don't tell him anything. Let him answer. Anything you say can and will be used against you. Ask him a question. Let him answer the question.
Right.
Because it's his duty to inform you. The burden of proof is on he who asserts, not he who denies. The burden of proof is on he who asserts, not he who denies. You don't have to prove shit. They are the ones that have to prove everything. You don't have to prove nothing. You have the right to remain silent. You can plead the fifth. Don't go in there testifying.
Right. What if I say I refuse to go forward unless you show me proof of your jurisdiction?
No, you say I will be more than happy. You got to trick these people. You know what I'm saying? Because they're not too bright. So you got to always come with some, type of way of, because you got to understand they following a script. They are actors. They rehearse all of this shit when they come into the courtroom. So you got to take them out of their script. So you agree when you're like, hey, I'd be more than happy to give you the information you requested up on proof of claim. Do a conditional accepted that you provide me X, Y, and Z. More than happy to give that to you. You always want to have the appearance that you are an agreeable person, that you are a friend of the court, that you are a amicus curiae. All of these different things. You're not here to be combative. You're like, okay, well, whatever. What's going on in here? You're trying to find out what's going on. Hey, give me the original charging instrument. I'll sign it right now. We can end this matter right now. Where's the original wet blue ink signature on the information, indictment, or accusation? Let me get it right now, the original. Provide that to me. Tell the prosecutor to provide the 1040. He needs to report this on his taxes, don't he? Isn't he going to make a profit from this? Aren't you making money off of this case? Well, you are going to report this to the IRS, aren't you? Be more than happy to do that. Can he just provide me with that information? I request that the Honorable Judge direct the prosecutor to answer if there are any more charges. Do that so they won't come with no superseding indictments and all of that. Ask them a question. I request that the judge direct the prosecutor to answer if the assessment for the charges are in his possession. I request that the judge direct the prosecutor to answer if the assessment for the charges are in his possession, along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. If those don't answer, I request that the judge state for the record that you do have subject matter jurisdiction. Make him say it. Because if he ain't providing nothing, if he ain't providing an assessment, if you don't have a 1040, if you don't got nothing, then how does the court have subject matter jurisdiction? If I haven't even seen an original charging instrument, it's no different than a foreclosure. If you come in with copies of documents and I object to the veracity and validity of those documents, then we need to address the issue of the authenticity of these documents, and the only way that can be rectified is if you provide me with the originals or an affidavit saying that you have those, which they're not going to do. So does the court have subject matter jurisdiction? Get it out of the judge. Get an answer. Get it on the record. Anything he says can and will be used against him, too.
Right.
I got another caller. Everybody, boy, got a lot of people on call today, but y'all just riding out, I see. Let me know when y'all get tired of hearing me talk. Let me bring this other call in. You can stay on the phone. 610-7711. You're on High Frequency Radio. State your business.
Peace, my brother Yusef.
Peace, bro. What's going on?
I'm loving you, man. I'm loving you, man. You putting it out there.
Appreciate it.
Out there. Yeah. I'm loving that. Just one question. Last time I talked to you, and I made that correction to my documents, requesting that assignment.
Right.
And what you're talking about right now, as far as jurisdiction and the subject matter jurisdiction, would this basically be in? Because you're talking about in the criminal court right now, right?
Well, it could be criminal or civil. It's the same thing, because when you're talking about like a third-party debt collector, all right, well, shit, they need some documents, too. You had okay, you said American Express, you're collecting $10,000 debt for American Express. Okay, motherfucker, put into evidence a contract you got with American Express to collect this debt. That's usually in the form of an assignment.
Right.
All right? And if you don't have an original assignment that's notarized with a legible signature, because what they'll try to do is come up with one, but it won't be notarized. The signature will be illegible. They're actually putting fraudulent documents into the record. You know, they got to provide you some type of evidence to support their claim. And if they can't do that, then they are not a real party in interest. And if they are not a real party in interest, then the court doesn't have subject matter jurisdiction. Okay,
now here's I heard you say the contract, blue wet ink contract. Now that assignment would be that way, and if they're saying, like, say for instance, I got little. I mean, I can talk personally. I have a little debt I discharged with Discover.
Right.
Okay. And of course, naturally they try to flip the script. But they have to come up with an original contract, right?
I was about to say, even with the original so-called alleged lender/thief.
Yeah, right.
They have to come up with a contract too, okay? But they ain't gonna come up with a contract, because the contract is usually what they use to monetize whatever they're doing. That was a negotiable instrument. They sold that. So they're not going to be able to. They're not going to have the contracts. It's like, okay, well, you know, come up with if you don't have a contract, what the hell is you talking about?
Right, but see,
you can't come in court with a contract. Why the hell am I talking to you? You don't have no original contract to show I have any obligation or duty to you whatsoever.
Yusef, you're saying, I hear what you're saying, but, you know, so when they come with these photocopied things, and I thought that under UCC for it to be a contract, there had to be two signatures. You can
challenge photocopies, here's another trick. This name of this show is Court Tricks and Traps.
There you go.
Here's another trick. Is this your signature on this particular document? How would you answer that? If I asked you, isn't this your signature, sir?
I'd say, no, sir, that's not legible.
Oh, no. Don't say no.
No.
Don't say no. No.
Okay. All right. Then what am I supposed to say?
You're supposed to say, you ask a question.
Oh, okay. Yeah.
It looks like a very good forgery. Do you have the original for my inspection? So I can make an accurate determination.
Beautiful. Yes, sir. Okay.
It looks like, in my estimation, a good forgery, but I could be sure if you provide me the original for my inspection. And then if they pull out, well, we have a signature here on your court paperwork that looks exactly like this signature. Well, can you prove to me that that's not photoshopped?
Now, when you say which one's Photoshop, which one are you talking about? If
they ask you anything, talking about if they want to compare signatures and anything, anytime it's on listen, I am an expert in, anybody who knows me knows this, I'm an expert in Photoshop. Okay. I'll take a signature off of any document and put on anyone in 10 seconds. I'll lift a signature off of something, okay? You cannot, that's something people need to take into consideration, all right? You cannot, you have scanners. You can scan, y'all go try this. Go scan your signature, then go to Photoshop. I'll tell y'all how to do it right now. Let me put this on the air. Let me pull up my Photoshop. And tell you exactly how to do it. You're going to scan your signature in, and if you're going to scan it on a white piece of paper, now if you're going to use, like, it's coming off some paper with your signature that has a colored background, it's going to take a little bit more work. You're going to have to erase everything around your signature. And you can use the eraser tool with the soft edge to do that. Next, what you're going to do, you're going to put select, and it's going to ask you for color range. You're going to click color range, and then a box is going to pop up. You're going to put your pointer on the outside of that box. It's going to magic wand everything in that color, but then you're going to come back around, and then you're going to click inverse, and it's going to lift up the signature, and you can put that signature on any document you want. Now, don't go out there and use that for legal purposes. This is for entertainment purposes only.
Yes, sir.
But I'm making a point. I'm showing you how you can take a signature and take it off a document and put it on anything. And if somebody want to come into court, I'll be more than happy to show you how to do that. I can do it on any document. So if I can do that, they can do it. Because they like to go get motherfuckers at the university and shit, been formally trained in the shit. You know what I'm saying? So they can do it too. So if anybody, you don't know if that's it. Once that document left your presence, you do not know what happened with that document. You do not know if that is the original document, if it's been altered in any way or anything like that. You need to see the original document that you signed.
Yes, sir.
Makes sense.
Makes a lot of sense.
All right.
All right, brother. I just wanted to kick that with you a little bit today. And I don't think you're rambling on, brother. I think that you need to just go ahead and expound on what you expounded on, because it's all pertinent. It's all important. You know, don't feel like you're doing nothing wrong, brother.
I know, but the gentleman, he listens to me all the time. I'm used to him.
Yeah, he's a good brother.
know. I ramble. Let me tell you why I ramble. I do ramble intentionally because I do know that other people are listening.
That's right.
And I say what the Spirit directs me to say.
Yes,
you know, that's another thing. I talk when I'm talking. The Spirit tells me to say something because when somebody asks a question, I know there are other people that ask questions, but I want to give all the details related to that, the nuances of it, because a lot of times we get tripped up on the nuances of things that we're attempting to do.
Man, I think you covered a little while ago about, you know, looking at the etymology of the word, you know what I mean, and how each word has a different meaning. That's the first time I had heard that, how the word will have a different meaning going into the different courts. Now, that was powerful.
Yes, I mean, I'm telling you, you have to. That is why it is important. Almost when you look in a Black's Law dictionary, almost all those words have double meanings. They have a commercial meaning, they have an at-law meaning, and an in-law meaning. Almost all of them. So if you're in a commercial court, you're going to use commercial terms.
Yes, sir.
And under article, now here's the interesting thing. Use an order. It says commercial. That's under commercial law. Well, when you look at 27 CFR 72.11, this is just for all you somebody just hit me up, said, yo, big brother, one day can I get you to explain in language that a 5-year-old would understand the 3 types of jurisdiction? Okay, I got you.
Yeah.
I got you, L, brother L, Ali L. I got you. I see you coming in. Now, I'm going to run back through that thing one more time. I'm going to see if I can break it down to the lowest common denominator. But under 27 CFR 72.11, this is what I always tell people, you know, it's like I was in a conference with an attorney one time, you know, and she was like, you know, in law school, you were taught that there are a lot of people out here that are just not using the Uniform Commercial Code properly in its proper context. And I said, oh, really? I mean, who are you talking about? Sovereign citizens?
Wow.
She can't wait to let that fly out of her mouth, you know what I'm saying? 'Cause, you know, I'm one of them damn sovereign citizens. And I just say on this show over and over again, because I know the feds is listening to me. There's no such thing as a sovereign citizen. Take us off of the terrorist list. We are not terrorists.
Mm-hmm.
Why are you trying to put your own people on a terrorist list? Why are you trying to find a reason to put your people on a terrorist list? And you black people, what the fuck are you thinking about?
Damn.
Really? Them is the type, I'm going to tell you, them is the type of black people, when you say brother, they'll be quick say, I'm not your brother. You know what I'm saying? They got some serious psychological issues going on. You are dealing with somebody who has a mental disability. I'm not your brother. I had one say that, Secret Service agent. I'm not your brother. Oh, yeah, look like me. I'm not your brother. I work for the United States government.
You know that's hurtful. Brother.
Okay, I got you. You got a good job. Okay. I'm sorry. I apologize. You have a good job.
No, that's not what I'm talking about. What I'm talking about is it's the damn truth. I'm talking about the truthfulness of it, brother. I'm talking about, we got him out here that's going to, I'm not your brother.
I'm not your brother.
You know what I mean?
Okay, I'm sorry to say that in a minute, boy. I'm not your brother.
Yeah.
They got to show, but they have to demonstrate that they are better at being a police than white people. They do. I mean, man, when you deal with black police officers, man, when I see a black police officer show up on the scene, I get nervous. I'm more comfortable. I'm serious. I've had more pleasant encounters with police officers of other races than I have of police officers of my own race.
Well, you know that's because of who's looking over his shoulder. See, he wants to make sure that the guy looking over his shoulders,
That's ridiculous. I mean, I had guys in DeKalb County. I'm going to put y'all on blast. Y'all up there tasing brothers because they don't want to get their fingerprints in their picture? You coming in issuing an order to tase this man? The fuck is wrong with you? He's black. Oh, everybody black. Oh, you don't want to give his picture, tase him. Man, you don't have authority like that, man. This man ain't been found guilty of nothing. You arrest somebody, they are innocent until proven guilty. How in the hell do you think you have the right to tase somebody for asserting their rights, you piece of shit? That's why we're doing this type of show, because you need to sue get their names, everybody's name, get their name, badge numbers or something, take their shit. Every fucking thing that they own. Put them back on the street as a normal person, throw their ass back in the pool, and they walk around, they're going to be scared then. When they take that badge and that gun away from them, all of a sudden they're a normal motherfucker again. Now they want to be cool. Now you want to be my brother. Just ridiculous, man. That y'all, and the way I go off on this because I've seen a lot of things. You know, and it's just a shame. I'm like, you know, I mean, you don't have no right to. I don't have a right not to want to be fingerprinted. And even though you're telling me I'm innocent until proven guilty, which is a lie. So if you arrest me and everything, and I tell you I don't want to be fingerprinted, and I want you taking my picture, you telling me I don't have a right to do that? That I voluntarily can refuse to do that? Give you my biological property? And you haven't proved a goddamn thing yet. All you got is allegations, unsupported allegations that haven't been given by a person sworn to under penalty of perjury with full commercial liability. You don't have none of that shit. Give me a break. I got a lot of people. I must have said something. They lit up like a Christmas tree. You can hold on. Let me bring in another person. 832-5863 on High Frequency Radio.
Good morning, Brother L.
Good morning. What's happening?
Man, this is one of your best days. You need to have some more days just like this where you just kicking it. And you just cut everybody off and just let us listen. I'm going to be listening to this for a couple of days. I got your sovereign citizen again. I broke open Court Survival Guide, page 3. Representing yourself as a sovereign citizen. That word keeps popping up in some of the documents that's in the Dropbox.
Yeah, but let me tell you about that document. That sovereign citizen shit is saying in there is some, don't use that terminology. However, that court survival guide, all that stuff that they got in there came out of One Man Out, which came out years before that. Now, the techniques that they got in there are good. It is good, with the exception, putting the flag out, doing all that. They give you a lot of information. I used that. All right, that was one of my main, when I was fighting my case, I used that. I used creditors and their bonds, law redemption in court. I studied the Gene Keating treaties, prison treaties. I studied, I had about 10. I had this Moorish document, too, that was very good that pointed out Article 9 of the UCC, how a superior claim is going to come under a treaty. That's how I found that out alone. That's why, I'm with the nationalization, but people need to learn how to utilize that in commerce properly. I don't think that's being demonstrated properly right now. I had this one very good document that broke down Article 1 and Article 3 courts. I had a outline of the law. I had all these different documents, and the reason that I would study all of them because when I would come into court and I was fighting these judges, the prosecutor went to my house and they went through all my paperwork and they found all the stuff I was studying. So they even sent it to me. She sent it to me in my cells that you basically like telling me, yeah, we found where you getting all this shit from. So what I would do, because I play chess, I'm an excellent chess player. I would do is I would study different techniques, and every time I came into the court, I would never come in with the same technique. So I've tried almost everything. I would come up with a different technique. I'd spend weeks in just memorizing what I need to say. and going over in my mind different scenarios that may be brought up in court, because that's what they do. When they find out that you know this information, they all get together, talk. It ain't no attorney-client privilege. You forget that shit. If you tell your attorney something, his ass is running right back to his homeboys and tell them every fucking thing you said. Believe that. So they're going to get together, and they are going to come up with a plan to address you when you come in. So they already got, okay, if you don't want to come over to the bar, we got to intimidate him and then coming over to the bar. Or, something. They're ready for you. You have to anticipate their moves and then be ready for them. And the best way to do that, like an excellent chess player has a lot of different defenses, has a lot of different attacks. If I'm playing somebody just don't know how to use a queen, I know to beat them, I just need to take their queen off the board. I'm going to trade out queens with them at the first instance. But a good chess player, if I got bishops left, I'm going to kill you with those. Knights, I'm going to kill you with those. Rooks, I'm going to kill you with those. Or if we take it down to a pawn game, I'm going to kill you with that. You got to be the same way with this particular information, because you don't know how they coming. But that's why you master principles, because if you get the principles down, it doesn't matter how they're going to come. That's why I say anything, ask questions. Just develop the skill of responding in the form of a question. So it won't matter what they say, because everything they say is a presumption. Everything. They don't give you clarity on nothing. Nothing. The judge will just make a statement. If the judge says something like, be quiet. What? Am I to understand that the honorable judge has made a judicial determination I'm not to be afforded my due process rights and freedom of speech? Are there no First Amendment protected rights in this proceeding? Is that what you're saying? For the record. Everything they say can be responded to, because they is doing fraud. And fraud in the beginning is fraud in the end. It never legitimizes itself anywhere in the process. They have to do fraud, because the first rule of the game is there is no money. So everybody has to be tricked into contract, because there's no money to pay for anything. And what constitutes money now is slaves. So the rich people today are the people who have the most slaves. So you got one group of people trying to enslave another group of people. Ask a judge, are you not a public servant, and watch that motherfucker get mad.